All right, welcome back, and as Karen said, feel free to move to the front if you'd like to. We do want this to be a fairly interactive session as we go into the afternoon. I got my coffee, and I'm the presenter, so that hopefully that doesn't scare you. My name's Tim Mullen. I'm the Director of Market Regulation at the NEIC. I've been at the NEIC for 27 years, and part of my responsibilities at the NEIC is to support the Producer Licensing Task Force. We are very, very fortunate to have three extremely knowledgeable panelists with us today, all involved with the NIPR Board of Directors. So, again, just by a show of hands, how many people in the audience are on the regulator side? I think the vast majority. Okay. So while we go about our business day to day, hopefully you'll hear today what some of the activities we do on the regulatory side, what is that impact on the industry side? What's working well, maybe where there's some opportunity for improvement as well. So just in terms of the introduction of the panels, real quickly, Kate Jensen, she is a partner with Steptoe law firm in D.C., works in the government affairs and public policy area at that law firm. We also have Roger Moore, who is the policy director in government relations for NAIFA. And then on the far side there is Wes Bissett, the president of the Bellamore Group, and also serves as the senior counsel of government affairs for the Big I. So we have a good cross across the industry, the financial advisors, some of the large P&C brokers, and then also kind of Main Street agents in the marketplace. So let's go ahead and quickly review the learning objectives for the day, potential solutions in today's producer licensing landscape and from the industry representatives. Discuss the role of compliance and technology. I know Karen talked a little bit about technology earlier today. I'll ask her about some predictions coming up. But we wanted to talk a little bit about the technology side because technology plays such an important role in where we are in the industry today. And then also some of the industry trends. And then finally there you'll see dynamic discussion. We can't have that without everybody involved in some of these discussions. So I have a set of topics that we will open up here. I know this slide is a little busy, but this is a slide that's essentially the roadmap for our discussion this afternoon. So we wanted to make sure everybody had a laundry list of the topics that we want to cover this afternoon. And then we also have some other topics that we were talking about just briefly before this session began. And some of the comments Karen made, we may go back to some of those issues with mergers and acquisitions, cybersecurity. We heard a little bit about 1033 waivers as well. So we may pull some of those topics back into the discussion this afternoon. All right, so let's go ahead and jump in to the topics here. And licensing uniformity and reciprocity. Is Richard still in the room? There's Richard. Okay. So let's talk a little bit about reciprocity and uniformity. What does it mean from the industry perspective? And maybe at a high level, what you're seeing from your perspective when it comes to uniformity and then reciprocity.
Okay, go ahead.
Okay, I'll jump right in here. So we're for it, uniformity, that is. And I should mention that the client I'm representing here today is actually the Council of Insurance Agents and Brokers. So those are the large commercial brokerage firms. We operate in the retail brokerage space, but also surplus lines markets. So we have a lot of licensing activity going on in those firms, and unfortunately we are seeing a slip in uniformity, and I think Pennsylvania put it really well in the last panel. Everybody wants to be a special flower, but if everybody's a special flower, then we are adding a lot of cost and complexity to the system and to the cost of doing an insurance business. And, in this day and age where affordability is a key topic of every conversation around insurance, we would really love to see a renewed effort to back off of the complexity, to simplify and streamline where we can, to make it easier for you all from an enforcement perspective and also alleviate all the burdens on your side. But then, of course, for industry, make it so that we can spend our time and resources on finding the best value and the best products for customers and not on answering 8,000 bespoke licensing questions for all of our registered producers.
Well, thanks for having me here today. It's a pleasure to see everyone. Yeah, certainly NAIFA's members, uniformity, consistency, reciprocity are all critically important. A lot of our members, they practice across state lines, and especially if you work at a bigger company, there are a lot of resources in place, and it can be sometimes it can be easier to juggle any complexities that exist. But NAIFA members, a lot of them are smaller agents. They work at smaller outfits, and so that consistency and uniformity is really important because sometimes they don't have the resources in place to do all the legwork that would be required without it. I'll just give you one example regarding the NAIC best interest forms. Most of the states have adopted the annuity and suitability transactions model legislation. You have the disclosure forms in place, and recently there was a state that was considering the disclosure forms, and for the most part it aligned with the NAIC model, but they were trying to insert some differences there that ultimately, practically would have had an impact on the agent. So you kind of look at it and you say, well, it's not that big of a difference, but when you have smaller members like ours who are working across state lines, it's best if they have one set of rules and regulations in place because ultimately it's more, as Kate said, it's more cost effective, and it just allows them to practice more successfully and be able to serve their customers much better.
Yeah, thank you, Tim. I'd like to start with a moment of personal privilege. The last 2 years that I've been at this meeting, someone in this room, I won't name them because I don't know who they are, has been kind enough to leave me with COVID when I've returned home. So let's just keep it at 2. Maybe whoever you are, maybe let's go the fist bump route this year, avoid handshakes and that sort of thing. But hopefully we can avoid a repeat of that. But going back to your question about licensing and reciprocity, I'll say at the outset that things are much better than they were 20, 25 years ago. I think we have to acknowledge that, largely because of the work that NIPR has done. Things are easier. We've taken advantage of technology to be able to get licensed and to get licensed in multiple states and all of that. But it doesn't necessarily mean that it is where it needs to be. The typical agency doesn't work in their small hometown anymore, and that's sort of it. They deal with their customers and friends down the street. I mean, they're operating at least on a multi-state basis across state borders typically, and in many cases operating in a tremendous amount of states. The cost of getting licenses and maintaining them actually hits smaller agencies more than it does larger ones. If you're Marsh, right, you got a team of attorneys and compliance people who can knock that out for you pretty simply. In some ways, I mean, I know this isn't their position, but if you're a bigger entity like that, having sort of a complicated system actually benefits them vis-a-vis smaller agents who don't have the financial resources and wherewithal to do that. We find so the cost of licensing hits smaller agencies. We see this in research that we do. They're paying a higher percentage of their revenues on licensing and compliance than larger entities are. It's not a shock. It's also surprising to find out that today that there's a remarkable number of agencies. I get calls about this all the time. People who say, can you recommend a vendor to me to help me through the licensing process? That even though NIPR has done what it has done and made tremendous progress, there are agents out there who say, essentially throwing up their hands and saying, I'm going to pay money to a vendor to help me essentially get licensed to be able to engage in the business that I've selected. So I think we have not necessarily a long way to go, but there are things that can be done to improve things. I guess I'll shut up after this comment. You guys have probably seen license plates and bumper stickers over the years that, say, think globally, act locally. I guess my admonition to regulators would be, as you're thinking about new requirements, be they statutory or via regulation, I'd urge you to think globally before you act locally. Those sort of small nits and requirements that if you're looking just on your state basis, and Dave talked about this, at the very last panel, they might not seem like a big deal, but if your state does something in this area and then another state does something in that area maybe slightly differently, or it duplicates the other requirements, pretty soon it becomes burdensome to meet all of those obligations. And at some point also, we need to kind of take a step back and say, what's the cost, the cost and benefit of the types of requirements that we're talking about here? Does the public policy benefit always outweigh the cost of what's being imposed? And I think sometimes, I think it's easy to do. We lose sight of that calculus.
Okay. Yeah, thank you. So you see a list of topics. So as we were doing a prep call, when we were talking about uniformity and reciprocity, these were some of the issues that the three panelists raised. So I don't know if anybody would like to jump into any particular topic, or if you want to start with the appointment process. There is a uniform appointment process. The uniform licensing standard is one appointment per company. My guess is that's maybe not as uniform as we might believe it is. So I don't know who raised that, but if anybody would like to talk about maybe some of the pain points around the appointment process.
Yeah, I think this one was mine. This is a huge issue for council members, and I think as Tim pointed out, we've moved away from the one appointment, one producer model, and now we're seeing appointment requirements by line of insurance within the same appointment relationship, and so on and so forth. I think we counted that there are maybe 15 distinct approaches across the states right now for the timing of appointments. Everybody's kind of doing that a little bit differently. And then, of course, we have the states that have done away with them completely, right? And so there's a ton of variations, which is why it's on our list of areas where potentially uniformity could be improved. But this is an area where some of the larger firms are employing legions of people just to keep up with appointments and appointment renewals. And it's kind of funny, right? If you look at the history of appointments, the public policy history, this is like a Civil War era concept where insurance companies were sending like guys out on horses to sell their insurance products across state lines. And regulators wanted consumers to have an avenue for going after the insurance company if they didn't get paid and they were supposed to, right? And so it started out as a function of somebody to act as the actual agent of the insurance company to accept service of process and give those consumers meaningful access to legal avenues. And fast forward today, and all the insurance companies are licensed, all the agencies and firms are licensed, all of these individuals are licensed. Everybody has agreed to accept service of process everywhere. It is not hard to reach people anymore. And so I think to Wes's earlier point, this is an area where evaluating sort of the policy benefits compared to the complexity and resources we are spending to maintain this system, this might be one of those topics that's ripe for that type of evaluation. And I'll be very honest, I'll say that the controversial thing here, the council is in favor of getting rid of appointments completely. That is our official policy position for the reasons I think that I just tried to articulate. I'm not sure if I did a great job of it, but sort of the questionable at this point policy origins of the framework, but also that we have these other better resources now for consumer protection and for tracking activities of individuals working for firms, working with a bunch of different carriers. For the council, it is not uncommon for our individual producers within a firm to have 24 or more appointments. So when you start extrapolating that out and multiplying that by how many folks we've got working at these firms, it gets pretty unwieldy pretty fast. So I think this is an area where we could do a lot. If we're not going to get rid of them, we could certainly do a lot to streamline and modernize the process and get everybody using that uniform process that Tim mentioned.
Yeah, no, so the one thing, appointments are interesting, right? Because I'll be in meetings with company people, and we'll talk about, the importance of reforming the agency licensing process, and the company people kind of tune out a little bit. They're sort of like, that's your, agent licensing, that's your problem. We got enough problems. And then we say, well, what about appointments? And then, now you've gotten their attention because the companies are ultimately the ones who are responsible for processing the appointments, paying the fees. That does not fall on agents. But where it does become an agent issue is because of the costs associated with the system, companies are oftentimes reluctant to give out it's not even give out appointments, it's to enter into contracts with agents. So it's restricting and hindering the ability of agents to get access to markets that they might not have otherwise. And in the hard market we find ourselves in right now, agents are looking for markets. Agents are too often working with limited options. They'd love to have more options. The appointment process, those requirements, has been a barrier to that. My feeling, my understanding is that the states that have banned appointments, the world has not come to an end. We've kind of been able to continue on. And in some ways, the licensing and appointment process, I kind of think of it as the legacy system of insurance regulation. It's kind of like we've got requirements and systems that have been in place for a long time. If we were starting from scratch, we might do something very different. But we've kind of patched it up and we kind of kept it going. With NIPR, we kind of can cover up some of the challenges that we have. But if we were really starting from scratch, would we require companies to notify insurance regulators that they've entered into a contractual relationship with a particular agent? That's what an appointment is. It's not, there's nothing that actually happens. It's a notice requirement. It's notifying these departments that you have a contractual relationship. I think Kate's absolutely right about the public policy benefits of this. The issues that regulators might be concerned about can be pursued and dealt with in other ways, especially in 2024. So, we agree. I think one of the practical challenges is states have become so reliant on the revenue that appointments generate that, let's not be politically naive. That revenue would need to be made up in some particular way. So how is that going to happen? If you go to a state and say, we're going to repeal the appointment requirements, but you don't have a suggestion for how that revenue is going to be made up, you're not getting anywhere. That's just political reality. So I think that issue has to be addressed as well.
That sounds like a carrier problem, Wes.
Yeah, right. Exactly.
Okay. Any regulator want to advocate against appointments? Any state that's out there? I know there's nine states that don't have appointments. What your experience has been? Oregon requires appointments, but we don't track any of them. They're not required to report. Okay. So Oregon has that. Can you say that again? Appointments are required, but because of the contract between the okay. Okay. All right. So if for those online, so Oregon doesn't track appointments, and you have not had any issues in your marketplace that you've seen. Okay.
So I think Kate made an interesting point. I think the ideal for a lot of people in the industry would be to eliminate appointments altogether. That maybe that is too big of an ask for some states, but to achieve uniformity within that process, there's a lot in that gray area between requiring appointments for every sort of line of authority and, every kind of circumstance you can contemplate and no appointments whatsoever. There's a lot of room for greater uniformity in that space, and maybe that can be something that states look at.
To take a closer look at that. Okay. Charlene, and there's a microphone, so we have a microphone coming your way, Charlene.
I don't really know if California is unique regarding its appointment process, but each individual does not have to be appointed to the insurer. The business entity who is appointed to the insurer can endorse those individuals to transact for the insurer on its behalf because they're acting on behalf of the business entity, and our appointments are perpetual as well as our endorsements, so we don't do renewals. I don't know if that's a way to resolve a problem. No? Okay. Yes? Okay.
The NIPR folks are freaking out over here.
Well, yeah.
So, yeah. I think you have a tougher audience in this corner over here. Look, I think that there is this issue of again, everybody handling appointments just their own little take on appointments, right? And so whether you're appointing at the entity level, the individual level, there's so much back end support. And Wes is absolutely right. Like technically, these obligations fall on the carriers, right? And they pay the fees and all of that. But the back end effort that goes into getting the carriers the information that they need and making sure that we have what we need when the regulators come calling to demonstrate that those relationships at the proper levels exist, it's still a huge burden on the firms and on, for the individuals working in those firms to try to track what's going on. And so I would say we're not going to eliminate them entirely. We just got to go with the one approach that we can get everybody on board with, right? Carrie, Lori, and Karen are nodding over here. Because I think that's the only way we're going to draw the unnecessary cost and complexity out of this space.
So yeah, we will move on. But I think the conversation here, if you haven't looked at your own appointment process, I mean, really take a look at it, because it does have an impact on the marketplace and consumers having access to agents and brokers, and they need that access. So take a look at that appointment process. All right, well, let's go ahead and jump into the next topic. Anybody want? You can choose one, or if you want to just keep going down the list. I do want to make sure we hit the most important topics that the three of you would like to address with the audience today.
Jump ahead or to the...
Yeah, we can jump. Yeah,
sure.
Dealer's choice.
yeah, dealer's choice. Yeah, that's right.
That's what I get for being 007. Well, I guess if we can jump ahead,
absolutely.
Yeah, sure.
Let's.
So I'll go ahead and go to the second bullet point, and I know the others will want to come back. So from NAFA's perspective and the other trades, and I think what has been discussed already touches on is, barriers to the licensure process, and are there unnecessary barriers in place that can be removed or at the very least mitigated? From our perspective, we see there's just a lot of difficulty right now for producers, and I think you can look at pre-licensing education mandates. You can look at some of the issues that have popped up recently with online and remote testing. You could look at exams and materials in different languages. That would obviously be very helpful. 1033, which I believe we're going to discuss shortly. These are all, I think, areas where the regulations, they can be improved. I'll go into a little bit of detail on the pre-licensure mandates, because this has been a big concern for NAFA. So, the pre-licensure mandates, obviously, are state-approved coursework that producers are required to take before they even sit for a license. And the data that we see is not, there's not a whole lot of discernible difference in testing outcomes between states that have pre-licensing mandates and those that don't have it. So it kind of begs the question, well, across the board, testing, pass rates are down, but that's across the board in states that have both the mandates and those that do not. So it does beg the question, are there regulations in place, are there barriers in place that we can remove or improve? And I think it's absolutely the case. You look at, well, I'm going to take a step back, actually, and touch on a broader point, if that's okay. So when you look at the producer workforce, it's aging, it's getting older, and I think I saw a statistic, it was 50% of all agents and advisors are over 55, right? So it begs the question, what kind of pipeline are we going to create to replace those agents when inevitably, they retire, and hopefully they have solid nest eggs, since this is what they do for a living. I don't know. If they don't, their customers will get onto them. But anyway, so we want to see a workforce that's a little bit younger generally. You look at the NAFA membership, I can tell you it is a bunch of, not old, but older. They tend the older demographic, right? And how can we incentivize younger people to enter the workforce? And I think some of these barriers, and we can discuss them a little bit more, would allow us to do that. So I'll leave it there, but if you want to dive into some more details, we can.
Any other thoughts?
I'll say that I think this is an area where I think that NAAC's done some good things. I mean, if you look at remote testing, like the vast majority, are there any states any longer that don't allow remote testing? I'm not going to ask that state to raise their hand, but maybe there's some, but most states have done that. So I think we could draw a line through that issue because you guys have all addressed that. Pre-licensing education is an interesting question. I mean, I'm going to step back too. From an individual perspective, we're not convinced that things are all that challenging and difficult from a licensing perspective, right? Like, what do you have to do to get a license today? You have to pass the exam. You've got to pass a background check, which maybe is easier said than done for some of us up here. And then you got to pay a fee. There's really not much to it. And then in some states, in order to qualify to take the exam, you've got to pass complete a pre-licensing education course. There's not that many barriers. If you're truly interested in entering the insurance industry, I don't know that that's a tremendous amount to ask of someone. Presumably, someone taking the exam is not going to just show up cold and take it. So whether they're required to take a pre-licensing class or whether they're doing something on their own, they're doing some form of studying. So for that reason, we've been agnostic about the education requirement, but I don't know that, we don't see this at an individual level, the same sorts of barriers to entry that maybe others do. I will say one exception to that is I do believe is the 1033 process, and to the NAAC's credit, that's something you're working on too, and maybe we can talk about in a little bit.
All right. Yeah, go. Any other comments on?
No, I mean, I don't want to, I'm not an idealist. I know that just removing the mandates is not going to create a flood of people, applying, taking the test and applying to become insurance producers. But, perhaps, and these are based on anecdotes that we've heard from some of our members, perhaps, you look at folks who perhaps they work they work outside of traditional business hours. They have multiple jobs, they're caregivers, whatever it might be, if you just remove one of these barriers, and obviously if they want to pass the test, they still have to be prepared. So even if it just opens up opportunities for, it's, like I said, not a flood of people, but if it opens up opportunities for some people, then from our perspective, that's a success. But certainly it's, I can tell you, absolutely there are disagreements, at times very strong disagreements on this issue. So
maybe one area where we do agree, I know there might be some in the industry who don't, is there has been discussion in the past about essentially watering down the exam. I mean, I think Richard said it well, where the exam is really just to ensure that people have entry-level knowledge and sort of the basic minimum knowledge necessary. I would hope that the conversation that we have collectively about barriers to entry doesn't lead to conversations also about sort of dumbing down the test in some way. I think the exam process can be improved, but trying to make it, an outcome where we're just allowing more people to come in, and that, I'm not sure that should be the public policy goal of the process.
I would agree with that. I guess there's a bit of a balance. Obviously, you want people who are entering the workforce to be qualified, prepared. You want them to be knowledgeable producers, because they play an important role. But you look at the pass rates. I believe NAIC released the 2023 pass rates just recently, I think maybe even today. And they, across the board, like I said a few minutes ago, they are quite low. And Carrie and I were just talking about this, there are many factors leading to that. But if you're looking at pass rates that are 40, 50% in some cases, and it's sort of a broad issue, then I don't think those are just random outcomes. I think that it could be a reflection of policy decisions and what's the difficulty of the exam, what's the scoring metrics, et cetera. So clearly people have to be prepared, but are there areas where are the tests too difficult? And I'm not saying one way or the other. I think it's important to have a balance there.
All right. Well, and we put that bullet point up because I think it is incumbent upon, regulators working with industry to understand, again, some of the requirements that are in place. Is it a true necessary consumer protection, or is it, rising to some type of barrier to entry? And what is that right balance? And I think states have probably, differences of opinion. We've seen some differences of opinion among industry as well. So just kind of keep that in mind as we go through. And pre-licensing education and remote testing seem to be two topics that are still on the agenda at the NEIC for further discussion. Wes, you had mentioned 1030. I know it's not up there, but do you want to talk a little bit about 1033s and that process?
No, sure. I mean, I think this is there's a lot. I mentioned this a little bit last year. As the NEIC is looking at its 1033 process, I would urge you as an organization and as individual states to look at what's happened in the banking industry. Congress in late 2022 passed a statute called the Fair Hiring and Banking Act. The banking world has essentially its version of 1033, almost the identical language that identifies the people who are not, traditionally who were not allowed to work in the banking industry. And that statute was revised recently by Congress. And so some of the things that law changed were that offenses that were older than 7 years old were no longer disqualifying. If there was an offense and you were incarcerated for it, if you've been out of jail for more than 5 years, you're no longer disqualified from working in the banking industry as a result of that offense. If the act that you committed was committed when you were 21 or younger, and that event is more than 2.5 years in the past, that's not disqualifying either. Congress, in the new law that was signed, said that expungements are no longer can't be the basis for denials. Things like possession offenses. So there are a number of crimes that Congress said we're not going to allow these to be disqualifying offenses anymore for people to work in the banking industry. And I think that ought to be a model for the insurance industry as well. I think the insurance industry has an opportunity here to do things similar to what the banking world has done. My prediction is if the regulatory community in our world doesn't do those things, Congress might step in and revise 1033 in ways that were analogous to what they did for the banking industry. So the federal banking regulators literally just issued rules. I think comments are due on October 1st that will implement these changes. There might be something that the regulators in the NEIC want to look to as you consider your process. I think it was talked about a little bit in the previous panel. I think there's some good work being done, but there can definitely be some things that can be cleaned up. I think in 2024 to require a 1033 form to require a notarization seems a little outdated, almost quaint. So like that kind of thing we can get rid of to perhaps among some more significant substantive changes.
Okay.
Yeah, I'll just say, I know there's active conversations going on at NAIC to, simplify the 1033 process, and NAIFA is fully supportive of those. The consistency is important, but I think at the same time, there can also be some experimentation. I think it was, I want to say it was Pennsylvania that, was it Pennsylvania? I'm trying to think. Yeah, Pennsylvania that would allow prospective applicants to pretty much get a preliminary review of their applications to see what the likelihood would be, that they could get licensed. And I don't know the outcomes of that. I don't know what resulted from it, but I think that seems like a good idea if you don't want to waste anyone's time. So something like that, as Wes said, limiting look-back periods on lower-level offenses. If people want to enter and there are no major conflicts there, no major security concerns, then certainly let's get more producers out there.
Tim, I don't have anything specifically on the 1033, but it's interesting that this sort of criminal history issue is a place where with the uniform application for producers for licensing, we're seeing a lot of divergence across the states, right? These are, a lot of the special flower questions are related to criminal history, but then special definitions related to convictions and so on and so forth. And so really do appreciate the work that's going on to drive that alignment with the 1033 waivers. I think there's an opportunity, and I wanted to say also for the uniform licensing working group, just really pleased to hear that there are going to be continuing discussions around the uniform application and tackling some of those tough issues, right? Like, reasonable minds can disagree on a lot of these topics, but right now we have special questions on things like citizenship, criminal history, prior bankruptcy, military service, cybersecurity certifications, non-resident income questions, these types of things. And everybody has a good reason for putting these questions on their application, but it would be great to see a forum like the Uniform Licensing Working Group utilized where everybody can come together and say, tell us why you think that's necessary. And let's have that conversation about whether we think the policy benefits outweigh, sort of the cutting down on the uniformity. And so I do think that this is a key issue. And we've heard from council members as well that some of these long in the past minor offenses still disqualifying folks from participating in the industry is becoming a barrier to entry that is meaningful. And so we'd love to see some of the types of things that Wes described being considered. So just bring it right back full circle, Tim, to the uniformity discussion.
And Karen, yeah.
This summer, NIPR had the opportunity to speak to a commissioners conference, and we talked about the issue of uniformity and reciprocity and really this regulatory backsliding issue. And one of the issues was around 1033 and criminal background check in criminal-related issues. And I will tell you, some of your commissioners were very distressed to actually find out what's being required in their states. So it was interesting that there was a real policy disconnect between what is being asked on your applications and what the policy perspective of your leadership really is. So I do think you're going to continue, especially as we've gone through a process of decriminalization around marijuana, as there is no appetite for looking at expungements, those kinds of things. And so I think you really need to take a look at it, because I think it's coming down the pike.
Any other comments on kind of the uniform producer licensing applications?
Not on that. You were talking about any of these items?
Well, and just any other comments on the variations you may see in the states when it comes to the application process? If not, we can move on. The one below there, Wes, I think you added the layers of licensing.
Yeah, no,
maybe talk
I don't have a suggestion. I was just going to vent a little bit, like therapy. So, I mean, think about the perspective of potentially an innovative entity that has an idea for an insurance program. They're not really big. They're only maybe selling, a few policies in a particular state, potentially. What is it they have to do to kind of get up and running from a compliance perspective, right? So, pretend this is Roger's endeavor, right? He's got to get licensed in every state in the country, pretty expensive. The Roger Moore Insurance Agency has got to get licensed in all 50 states. Most states are going to require, even though they shouldn't, they're going to require the Roger Moore Insurance Agency to register as a foreign entity with the Secretary of State, which, is massive bucks in states. So you're talking, we're spending tens of thousands of dollars to get just licensed and credentialed. We're not even appointed yet before we're selling any policies. It's a massive burden. Like if we really were starting from scratch, I'm not sure that's the system that we would come up with, and I don't have a clear and easy answer for it, but I'm identifying the problem and the issue, and the smart people in this room can maybe sort it out. But it's a challenge, like and then to try to renew all of those licenses and registrations annually or periodically is a challenge as well. One of the things that NARAB did, it may never come into existence, but NARAB would have said that for NARAB members, it would not have required, NARAB members would still have had to register with the Secretaries of States in their resident states. That's going to every business is going to have to do that, but there's really no public policy benefit to doing that in other states. And NARAB would have said that you don't have to do that on a non-resident basis, and that would save insurance agencies literally tens of thousands of dollars just there. Some of those fees are, hundreds of dollars or more. I know that's not an insurance regulatory issue, but it's a big burden for the members that Kate and Roger and I represent.
Yeah, on the NARAB front, couldn't agree more. NAFA was a strong supporter of it when the bill passed in 2015, I guess it was, and we put out an action alert again last year to all of our members, trying to urge their congressional members to move forward with it, because it would cut down a lot of time and a lot of costs. And again, to my initial point I made earlier, for people who represent smaller agencies, it's really critical.
And I don't think I can leave this panel without saying NARAB at least once. So NARAB, we're also for that.
And you want to, for those who aren't, but you want to maybe just talk a little bit about the background of NARAB. I know there are some newer folks here, and right, all three of you have an interest in, right, NARAB membership for your members.
Let me see if I can give the 30,000 foot level.
Go for it.
So NARAB 1 started out as a big freaking stick by the federal government to try to get the states aligned on their licensing processes and on reciprocity. And the threat was, if the states do not get, a majority of the states get their licensing to a particular standard of uniformity and reciprocity by X date, federal government is stepping in and we're going to take over a bunch of these activities. Fast forward to 2015, NARAB 2 comes along, and that is just a straight up, we're establishing this thing. But here's the kicker. In order for NARAB to be established, there's a 13-member board that has to be appointed by the President of the United States with the advice and consent of the Senate. And I don't know if anybody's paying attention to what's going on in Washington, D.C., but nothing is happening in Washington, D.C. And NARAB is way, 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 way far down on the list. So we're going on 10 years of NARAB 2. The board has never been constituted, and I think everybody agrees that the presidential appointment and the advice and consent of the Senate is the real hurdle there. So in fact, we got a call at Steptoe just yesterday from our friends at APCIA, the carrier group, saying, what can we do about this, right? And so investigating legislative fixes to the NARAB 2 statute that would remove sort of that fundamental hurdle to get this thing established. The key with NARAB 2, though, is that it still relies on the home state model, right? You get licensed, you follow the requirements for your licensure in your home state, and then you go through NARAB for your non-resident licenses. If you're a member of NARAB, you don't have to be. And then it does reserve very important functions for the state-based regulatory system, right? So consumer protections, unfair trade practice requirements, so on and so forth. So it's not a total usurping of the state-based insurance regulatory system, but it really is meant to streamline and standardize that non-resident licensing space. Did I do an okay job?
Yeah, no, I think that's right. So actually the state licenses will remain in place. NARAB would just be a mechanism for obtaining those state licenses. Entities would still even have to pay those fees to that NARAB would collect and remit, because as we talked about with appointments, revenue, making up revenue is critical, and everything outside of the credentialing process, everything that an agent or broker would do is still subject to enforcement by state insurance regulators. So none of those issues would be displaced. I think one of the challenges in structuring this is it seems like it would be easy to just create a board and it could go off and running. There are constitutional questions that come into play. So, there are potentially ways around some of that. But, those are conversations that are likely. And so the fact that NARAB statute passed nearly 10 years ago, 3,500 days ago, and the board hasn't been established. As you can hear, there's starting to be conversations about how do we, what else do we do? There was talk at one point about some of the, could there be other things that Congress could do in preemptive ways to address some of these licensing challenges too. I think some of that conversation is back on the table as well.
And I think that also points to the importance of states, right, being vigilant in the standards we do have in place that the NAIC members have adopted to make sure those are followed, and you're not modifying those without really some significant thought to that. We're right about at 5 minutes. Are there any questions from the audience that anybody would like to ask the panelists?
Tim, while we wait, I want to give a shout out to the NAIC too for its work on the public adjuster licensing models, the revamps that are going on there. There are some major problems happening in the marketplace, and the work that's being done, I think, is incredibly important. David from PA talked about that a little bit ago. I had somebody tell me lately that they were getting, I believe a regulator that was doing some enforcement stuff, and they were getting calls. They had been in contact with a public adjuster. When that person called back, the name that showed up on the caller ID was like a contractor name. So some of these entities are very closely woven with contractors, and there's some really bad stuff going on out there. So I want to just commend the NAIC for the work that's going on there. Some real good consumer protection work.
All right, see a question there.
Well, I had a question, and I also had a comment in regards to the uniform producer application. I love that that's being discussed, because I was in the industry for 18 years helping producers get licenses. So many times it's specifically stating on question 1A with the DUIs. And there are so many states that will reject, issue a RIRES for answering no, even though it states that. So then we would have to turn in and say yes every time to states that are not reviewing that. So that inconsistency is frustrating. With Connecticut, we take it for face value as what we say. But one of my questions was in regards to the pass rates. Do you find that there are pass rates with higher for states that require pre-licensing, or are all the states seeming to be on the same platform if they require it or don't require it?
Anybody reviewed those since this morning?
No.
Yeah, I have not reviewed, but I think certainly the analysis that's been given to me from industry would suggest there's no difference in terms of pass rates, whether a state has pre-licensed education or not. And I will just reference, because I think there's some confusion around the NAIC's uniform standards around pre-licensing education. The standard is a state does not have to have pre-licensing education. However, if a state does, it should be 20 hours of pre-licensing education. But the standard is actually no pre-licensing education is required. And I get questions about that, but that's the standards that is currently in place.
I wonder the answer to that question, because I don't, and I would defer to people like Richard if they're still in the room, but I think it would be challenging to do an apples to apples comparison, right? Like if state A has a particular test and there's pre-licensing required, and state B has that same test and pre-licensing is not required, then you could do that analysis and maybe draw some conclusions. But if the tests, I don't know, I just think it becomes challenging because the tests are different and some have pre-licensing and some don't. And so there's some smart people in the room that may have a better response to that than me.
All right. Other questions? Any other comments from the panelists? We have about 1 minute left here.
We have to talk for one more minute for y'all to get your CLE credit.
So we have 1 minute left.
So I do have something. I hadn't even had a chance to see that you were talking about stuff that's kind of hit today in the news. If somebody wants, if you haven't seen it yet, insurance has kind of hit the news nationally because former President Trump was texting about auto insurance rates today. So if you haven't seen that, I wonder if it'll generate some calls to your departments over the next couple of days about too high insurance premiums.
Fun.
Are we?
I think, look, closing comment on behalf of the council, I do think that it's worth taking this uniformity discussion seriously. I do think that there's a lot of extra cost and complexity right now that we don't need that's driving a cost for everyone. We all know that that lands somewhere, and it's typically on consumers. And so really encourage everybody to lean into these forums and these processes that we have at the NAIC to have those conversations around uniformity. And a lot of folks have not been around since Graham Leach Bliley and NARAD 2. There's a lot of education to be done about why it's important and why it matters, and honestly make y'all's lives so much easier too. So maybe that's the motivation, that's the winning argument. But really appreciate all the effort in this space from industry's perspective.
No, I agree with that. I think, as I said before, I think the system compared to 20 or 25 years ago is significantly better. I mean, we shouldn't lose sight of that. But as you were thinking about these issues, one thing we would urge you to do, as I said before, is to, think globally before you act locally. So keep that in mind. And also ask yourselves, if we were dealing with a particular issue or requirement from scratch without any history, how would we deal with it? And try not to be encumbered by the past or things like, I know that's easier said than done, but if we can think about these issues with that mindset, I think it'll potentially bear some fruit. But thank you all for the work that you do.
All right, well, I want to thank the panelists. I know they're extremely busy, so we really appreciate you taking the time to come to the summit and talk about these issues. So with that, we'll conclude. We'll be back in about 5 or 10 minutes, and let's thank the panelists.